My name is Rebecca Pskowski, and I will be speaking today about certain underwriting members of Lloyd's of London v. Florida Department of Financial Services. Unlike my colleagues, the case I'm going to present to you today has nothing to do with boats. There are no charter parties, no oil record books, and no maritime liens. However, I hope I will be able to convince you that this is an important case for maritime practitioners to be aware of. So this case, certain underwriters, comes out of the Second Circuit, and it's regarding the standard for vacating an arbitration award under the Federal Arbitration Act. The Society of Maritime Arbitrators of New York is in New York, in the Second Circuit, and this opinion, as I will explain, will affect the enforcement of SMA awards going forward. So the case we're talking about is a reinsurance dispute, and the underwriters denied the reinsurance claim of ICA, the Insurance Company of the Americas, and the underlying insurance claim was related to workers' compensation claims. After the underwriters denied the reinsurance claim, ICA invoked their arbitration clause and they commenced arbitration. In this case, arbitration was by tripartite panel in a format very similar to that used by SMA. There were two party-selected arbitrators, one selected by each party, who then between them agree upon a third neutral or umpire arbitrator. ICA selected Mr. Alex Campos. At the routine pre-arbitration disclosures, Mr. Campos disclosed that the full extent of his business and personal relationship with his appointing party, ICA, was that 10 years earlier, he had tried and failed to go into a business deal with an ICA director. The panel conducted its arbitration and found unanimously for ICA, awarding them more than $1.5 million. It later emerged that Mr. Campos had not been entirely forthcoming in his disclosures. Campos was the CEO of an HR company called Venture, and Venture actually shared a suite of offices with ICA. During the course of the arbitration, Campos, in his role as CEO at Venture, had hired an ICA director who was also a key arbitration witness to be the new CFO of Venture. Neither of these facts were disclosed, and there were additional, more minor contacts that were not disclosed. Can say the duty to disclose during arbitration is ongoing. If something comes up during the arbitration, the arbitrator has a duty to disclose it. So, based on these facts, the underwriters filed suit in the Southern District of New York to vacate the arbitration award on the basis of Campos's evident partiality. Evident partiality of an arbitrator is one of very few enumerated statutory grounds on which to vacate an otherwise valid arbitration award under the FAA. Since the enactment of the FAA, vacating an arbitration award has been very difficult by design, and as we will see, this case will make it even more difficult to vacate an arbitration award going forward. The Southern District of New York applied the reasonable person standard, which was at the time of the initial case the standard in the Second Circuit for evident partiality. Under the reasonable person standard, an arbitrator displays evident partiality where a reasonable person would have to conclude that the arbitrator is partial to one of the parties to the arbitration. The standard comes out of a case called Morelight, where the arbitrator whose actions were contested was the son of an official of the arbitrating union. And that's where we got the reasonable person standard. A reasonable person would assume a son would be partial to the arbitrating union, which his father was an officer of. So using this standard, the SDNY found that a reasonable person would conclude that Campos, by concealing the fact that he shared an office suite with his appointing party and by hiring an arbitration witness during the arbitration, a reasonable person would conclude that Campos was biased, and the district court vacated the award. ICA appealed to the Second Circuit, and the question before the court was whether Campos, because he was appointed by ICA, he was a party-appointed arbitrator and not a neutral or umpire arbitrator, whether because he's appointed by the party, he should be held to a lower standard for evident partiality than the existing reasonable person standard. So this is a question that has been percolating through the federal courts for about 2.5 decades. The 11th Circuit was the first federal appeals court in 1993 to establish a lower standard for party-appointed arbitrators. And since then, the 8th, 7th, and 6th circuits have followed. The 8th Circuit went so far as to say there is no requirement that party-appointed arbitrators make any disclosures to the parties. So it's important to note that this distinction between neutral arbitrators and party-appointed arbitrators is entirely judge-made law. The Federal Arbitration Act does not distinguish between the two, and it just simply says that an award may be vacated for the evident partiality of an arbitrator. The Second Circuit has considered this question before in 2012 in another reinsurance dispute, Scandinavian Reinsurance v. St. Paul Fire and Marine Insurance. And in that case, the Second Circuit ultimately didn't answer the question. They decided that the party-appointed arbitrator in that case did not display evident partiality, even at the existing high reasonable person standard. So, about 6 years later, the Second Circuit has returned to this question of establishing a lower standard with our case, and here they decided to follow those circuits which have adopted a lower standard. They found that while Campos's behavior would be evident partiality under the reasonable person standard, they were going to state a new standard and say for the first time that in the case of a party of appointed arbitrator, evident partiality will only be found if either there's evidence of actual bias or partiality in the award, or when the arbitrator is shown to have violated a contractual term, a contractual qualification for being named an arbitrator. In this instance, the contract between IC and the Underwriters required disinterested arbitrators. So if Campos had been shown to benefit financially in any way from the outcome of the arbitration, that would be disqualifying. So the district court opinion was vacated and remanded for reconsideration under this new standard, and that's the case. Now to its application for maritime practitioners, as I said at the outset, SMA uses tripartite arbitration in a way very analogous to the arbitration that happened in this matter. However, the SMA ethics rules are very clear that all arbitrators, including party-appointed arbitrators, are expected to remain completely neutral and impartial throughout the arbitration. And it's well established that courts will not vacate an award for an arbitrator's violation of his organization's ethics rules. In the noted case, Campos was a member of an organization analogous to SMA, and it appears that he violated the ethics rules of that organization, but that has never been a ground for vacating an arbitration award. However, as I explained with the court's holding, courts will vacate an arbitration award if an arbitrator violates a contractual qualification to sit as an arbitrator in the given arbitration. So my suggestion going forward, if you want to assure your clients that they will have New York maritime arbitration by neutral and impartial arbitrators, they should specify by contract in the arbitration clause that their arbitrators be neutral and impartial in compliance with SMA ethics rules. That's my case. Thank you.